His contributions to the laws of many countries has also been immense. Not least, many of you will have heard of his serving as the chairman of the Commission of Inquiry into Abuses in North Korea. That was a commission of inquiry undertaken at the behest of the United Nations, and its report last year into the atrocities in North Korea made world headlines. Justice Kirby is here today to speak about equal marriage and justice. It's obviously a topic of enormous resonance here and now in this country, where by legislation equal marriage has gone through just recently, but where in Justice Kirby's own country, Australia, it has been controversial and has not yet been enacted. The first equal marriage legislation was in the Netherlands in 2001, and since there you've had equal marriage brought forward by legislation of Parliament in some countries, so Britain, New Zealand would be other examples of that occurring, but also by referendum in Ireland recently, also by judicial decision, most obviously by that of the Supreme Court of the United States just earlier this year. So it is an incredibly opportune time for Justice Kirby to talk to us about what's been happening in the different jurisdictions and what that means for justice in our society. Justice Kirby is someone who, of course, is uniquely qualified to talk on this topic because he became Australia's first openly gay judge, and as someone serving on the highest court in Australia, it's difficult to remember, I think, how brave and courageous that was at the time. And in, I suppose, a Michael Kirby understatement, he did this simply by altering his entry in Who's Who. So where it at the start had his biographical details, he added the fact that Johan was his partner. And it's again something that at the time he again in so many ways has been courageous on the behalf of equal rights for lesbian, gay, bisexual, transgender people. He's someone who, we were just talking at morning tea earlier today about the fact that in Australia today, unlike in the New Zealand universities, there are some faith-based Australian universities, and just recently he's written to one of those universities where that university had banned LGBT students from meeting. It had said they weren't allowed to form a society within that university, a Catholic-based university in Australia. And again, he took that on, he wrote to them and said that this, in terms of the well-being of those students, was quite horrendous. So just as he's taken on the North Korean government, so he took that on. And if you read his biography, A Private Life, he talks about quite a number of years ago going to Zambia, talking to the judges there about AIDS and talking to them again about all sorts of topics that all sorts of people would be afraid to raise, and he has courageously been willing to do so. Michael Kirby was very instrumental just a few years ago when he first came to visit the law school and saying, what were we doing about the helping and supporting our LGBT students? And at that stage we set up the Rainbow Law, which is the law school's LGBT network, and Justice Kirby very kindly agreed to be the founding partner of that group. And so I'm very pleased today that we have a number of our Rainbow Law students here and here to again see Michael Kirby speak. I'm also very pleased that we have Justice Muir here today with his partner James, because Justice Muir joined the High Court last year and he agreed to become co-patron of Rainbow Law together with Justice Kirby, and that for us I think is an incredible signal to our students of the way in which LGBT rights are not only important, but that people need to stand up and be proud of who they are in the law and elsewhere in society. So it really is a very great pleasure today, on behalf of everyone here and on behalf of the Faculty of Law, to ask you to welcome Justice Michael Kirby.
Thank you very much, Dean Stockley. Thank you for your welcome to the Law School of the University of Auckland today. Although I must say, I think you have been receiving lessons from Kim Jong-un in the way to work people very hard and to make sure that they deliver a maximum production for the benefit of the nation and the Supreme Leader. honour the Maori people. Tēnā koutou, tēnā koutou, tēnā koutou katoa. We learn in Australia from the sincere way in which that moment of reflection and of the injustices that have been done in the law and in society needs to be reflected upon, so that we correct the wrongs of the past and address ourselves to the right path for the future. My talk to you this afternoon is divided like Caesar's Gaul into three parts. The first is to do what is always done in a medical conference. You have to acknowledge any interest whatsoever that you may have that may make your observations in the talk that you're going to have affected by an external interest. The second will be to review the history of the reform of the law and the changes in the law affecting LGBTIQ people, lesbians, gays, bisexual, intersex, transgender, and other queer people in recent years in three cities, a tale of three cities, of the changes that have been affected in Wellington, New Zealand, with which people in this audience will be well familiar, of the changes that have come about recently in Washington, in DC, in the United States of America, and thirdly, of changes that have been attempted and are still underway in Canberra, in the capital of my own country, Australia. And then finally, I'm going to try to draw 10 lessons for how the extraordinary development that has been achieved in the relationship recognition of LGBT citizens in these three countries has actually occurred in the last 10, 15 years, and how the lessons can be learned from those achievements for other countries which are recalcitrant or which are holding up the journey of progress. Now, my first point of acknowledgement relates to my own sexual orientation as a gay man. I don't think this will come as a terrible shock. I don't think it's likely that there will be a big walkout, but earlier on that is likely to have led to some dismay and disquiet or feeling of anxiety or unpleasantness, or discomfort by people who receive that news. Well, the answer is you've got to receive it and get over it. And if you have a problem, you've got to have a glass of water, possibly an aspirin, a good lie down, and you will feel much better after that. And receiving the knowledge and information is good for you, because it's ultimately knowledge and information based on science and reality, which is always good for everybody. I too want to acknowledge the presence here of Justice Muir and of James. I welcome their comradeship in being here. When I heard of Justice Muir's appointment, I proposed to the Rainbow Law group at the University of Auckland that they should invite him to be a co-patron. And today I've indicated that they have to go immediately on a very quick search to find at least one woman patron of the Rainbow Law, because it's not a good look to have just two gentlemen. We need people from every community and every different gender. Now, I turn now to the story of the last 15 years. Before I do so, I should say, just closing off the first paragraph of what I have to say, that I don't feel in addressing the issue of marriage equality that I bring a biased viewpoint. I bring an informed viewpoint. I bring a viewpoint that supports the notion and availability of marriage equality, which you have attained in New Zealand by legislation and which has been attained in the United States by judicial decision, but it's not something that immediately affects me. I have been with my partner Johan van Vleuten over the past 46 years. 46 years, most of my public life. We met in 1969 and I was appointed to my first public office in December 1974. So we had already, by that stage, been together for 5 years. And we had twice crossed the mighty plains of Asia in a combi van. Anybody who can survive 1 year, let alone 2 years, in a Volkswagen combi van with another human being is almost certainly bound to face the long haul and the long distance. And so we have been together for 46 years. To me, it has been a great blessing. And I think it's been a great benefit to my public life. I believe that it's been a benefit for the people in public life with whom I have worked. In fact, in the High Court of Australia, everyone, without exception, really liked my partner. They found him, as I do, very, very witty and amusing. And they found him extremely direct. He is from the Netherlands. They are very direct people. Not all of them had quite the same feelings of love and affection for myself, but everyone liked him, and I have no doubt that it was good for them to work and to socialise with my partner of 46 years. We had outlasted most of the weddings we went to, all that confetti we endured, all those gifts we gave. Many of them broke down and fell apart in misery, grief, and in the divorce courts, but we continue on. And it's not at all sure for us that we would get married if marriage were available in Australia. The reason for that I can quickly explain, I think, that if you have had 46 years without benefit of a piece of official paper, you don't really need or feel the need for the benefit of the piece of paper. In fact, seeking the piece of paper from the state would perhaps in the back of our consciousness appear to be asking for something which was essential, which you didn't have over 46 years. There is another factor that if you disturb the integers of a very long-term loving and supportive relationship, you have to run the risk that things might change. Would it change if you moved from pure love, affection and support to a relationship based on law and based on the law of the state? Would it alter in its quality or kind? We have naturally spoken about this, but haven't made any final decision. Perhaps we would get married if only to honour those who in Australia have worked and struggled hard to get marriage equality. We certainly believe marriage should be there for fellow citizens who feel the need of it, but we are not entirely convinced that we want it. And I explain that at the start so that you'll understand that I can approach the issue of marriage equality with a degree of dispassion, looking at it as a lawyer who believes it should be there, but not bent over in an ardent and urgent desire to have it. To us, it's an intellectual entitlement, not something that we feel a deep and immediate need for. I've been to recent events in Australia that happened soon after the refusal of the coalition parties in Australia to agree to a conscience vote in the Australian Federal Parliament on the issue of marriage equality, which refusal put an end for the moment to the attainment of marriage equality in Australia. And I was told of a number of people, it was mentioned at the functions, who are now in advanced years, who one of whose partners was about to die, and who had set her heart upon the availability of marriage. For such a person, the issue I'm going to speak about is not just an intellectual paradigm, it's a matter of very deep, personal, felt need, and I respect those who feel that way. I just indicate to you at the outset, I don't feel that way. I'm looking at this matter as a lawyer, as a former judge, as a citizen, and it's therefore a cause I feel I can add my contribution to. Now, the tale of three cities must begin in Wellington, New Zealand, with the steps that took this country on a journey that ended with the adoption of the Amendment Act to the Marriage Act in this country. Where you start exactly is a matter of conjecture, but certainly one important step on the road was the decision in 1986 to present to the New Zealand Parliament legislation, amending legislation to change the criminal laws that provided for crimes and for penalties upon conviction of persons who were convicted of the so-called unnatural crimes. In New Zealand, it only ever applied to males, and it reflected a particular British view of sexual relations, which in turn had been borrowed from Old Testament provisions in the Bible, and it was an export which, with the many wonderful gifts that the British exported to their empire, they gave to every country that was ever under the Union Jack. Every one of those countries received its anti-gay law, sodomy law, crimes, so-called unnatural crimes, which continue to afflict 42 of the 54 member countries of the Commonwealth of Nations. Those crimes are still solidly and apparently immovably in place. But in New Zealand, the step for reform came about a decade after the reform, 2 decades after the reform was introduced in England in 1967. The reform in New Zealand came in 1986. And by that time, I was the President of the Court of Appeal of New South Wales. I was a close friend of Sir Robin Cook and of many other New Zealand judges. I came over here many, many times, and I knew many of the actors who were involved in the New Zealand moves to reform the criminal law, including actors in the National Party, which was in government shortly before this, and then in the Labour Party, and I mention in particular Fran Wild MP in the Labour Party, whose bill was enacted in 1986. Until you had that reform, you couldn't even begin to think about relationship recognition. If all sexual acts between males, however consenting, however conducted in private, however limited to one person, were criminal, then you can't start to think about admitting as lawful a relationship which will involve such acts. And accordingly, at least for males, it was unthinkable before 1986. So I pay a tribute to Fran Wild and for those in the New Zealand Parliament who enacted the law. It didn't pass with a huge vote. It was extremely controversial in this country. It had already been enacted in many of the states of Australia. The reform in Australia had begun in South Australia in 1974 under the government of Don Dunstan, but in New Zealand it came about in 1986. Then in May 1996, a decade later, the High Court of New Zealand, in a case called Quilter against the Attorney General, ruled that the Marriage Act 1995 did not envisage, as the applicants asserted, marriage between persons of the same sex. The plaintiffs had argued that the Marriage Act 1955 of New Zealand did not specifically restrict marriage to opposite-sex couples, nor did it expressly forbid opposite-sex relationships from being a marriage. However, the plaintiffs had another string to their bow, and that was based upon the Human Rights Act of 1993. That act prohibited discrimination on the basis of sexual orientation, whilst the Bill of Rights Act 1990 created a right to freedom from discrimination on the grounds in the Human Rights Act, including sexual orientation. And the Human Rights Act of 1990 also provided that interpretations of legislation consistent with the Bill of Rights were to be preferred where possible. However, the High Court of New Zealand, applying the test for the meaning of marriage at common law, which had been expounded in England in the case of Hyde against Hyde in the 19th century, held that this restriction of marriage to opposite-sex couples was implied in the use of the legal term marriage, and that legal term had imported the common law definition. And therefore, under the Act as it then stood, you could not have a same-sex marriage in New Zealand, because that had been outside the contemplation of the Parliament of New Zealand in enacting the Marriage Act with a legal term which had a settled definition in the common law. And so the High Court of New Zealand rejected the claim, but it went on also to hold that the limitation of access to marriage was a justifiable, to opposite-sex couples, was a justifiable limitation within the Bill of Rights Act of 1990 of New Zealand, on the basis that that was what marriage had always been. Define the category, and then, having defined it, to hold that it was only available for that category was all that could be expected of a marriage so called. That decision was appealed to the Court of Appeal of New Zealand in December 1997, and in that year that decision was delivered by the Court of Appeal in Quilter against the Attorney General, and the Court of Appeal of New Zealand held that the High Court had not erred in its conclusion on either of the 2 points. First, that it was not within the language of the statute, and second, that interpreting it in this way was not contrary to the Bill of Rights Act. Justice Thomas dissented. He said, well, he was prepared to go along with the first of the findings, but it was obviously contrary to the Bill of Rights Act of 1990 because it was discriminatory on the ground of sexual orientation, which was a ground recognised in the Bill of Rights Act. And so he disagreed with the decision, and he dissented from it. When I read Quilter when it came to Australia, I must admit that I thought that the majority judges of the Court of Appeal, as a matter of legality, technical legality, had got it right, and that their decision, and not Justice Thomas's decision, was correct. I have done penance for that original view on many occasions in New Zealand, including in the presence of Justice Thomas in a most celebrated and very well read public conversation which I had with Justice Thomas. All of which goes to show that one's training in the law can often prepare you for formal approaches to issues which lack the bringing of a fresh mind to the issue, which Justice Thomas, I believe, did. He brought a fresh mind, and he said, well, it may be that that's what Parliament intended by the use of the word marriage, picking up the interpretation of the 1860s in Hyde and Hyde, but obviously he thought it was obvious that marriage was, that to refuse marriage to same-sex couples was contrary to the prohibition on discrimination on the grounds of sexual orientation. However, majorities rule both in Parliament and in the courts, and so Justice Thomas's dissent did not affect the outcome, and that outcome then stood for 15 years after the decision was handed down in Quilter. In 2002, in a case called Jocelyn against New Zealand, the decision in Quilter was effectively challenged before the United Nations Human Rights Committee, and it was contended that New Zealand, as a party to the International Covenant on Civil and Political Rights and to the first optional protocol under that covenant, was answerable to a complaint that it was in breach of the covenant, and that should be so found by the Human Rights Committee established by the ICCPR. That argument failed in the Human Rights Committee, which held that the unavailability of same-sex marriage in New Zealand did not violate the International Covenant on Civil and Political Rights. So that outcome was a blow to those who in New Zealand were seeking to use the Human Rights Committee to stimulate consideration of the human rights situation resulting from the decision in Quilter. In May 2002, Louisa Wall, a member of Parliament for the Labor Party, did not accept either the majority Court of Appeal decision nor the decision of the Human Rights Committee, and she introduced a marriage definition of marriage amendment bill as a private member's bill into the Parliament of New Zealand. The purpose of her bill was to amend the definition of marriage in the Marriage Act so that marriage would henceforth be the union of two people regardless of their sex, sexual orientation or gender identity. The effect of her legislation, if adopted, would be to allow same-sex couples to marry in New Zealand and also to have access to all rights available to married couples, including adoption. On the 26th of July 2012, indicating once again the importance of timing, of chance and of fortune in all matters of this kind, the bill presented by Louisa Wall was drawn from the private member's bill ballot in the Parliament of New Zealand, which gave it the opportunity to be voted on in the Parliament of New Zealand. Immediately, both Prime Minister John Key for the National Party and the opposition leader David Shearer for the Labor Party stated that they would vote in favour of the bill at all stages. However, they agreed that their parties, the members of their party, should have a free conscience vote on the matter. Having conscience votes on matters of this kind is not unknown. The Family Law Act in Australia, for example, with important changes into family law, was the result of a conscience vote in the Australian Parliament. On the 29th of August 2012, the first reading of Louisa Wall's bill passed on an 80-40 vote, with most major parties, both major parties, having the conscience vote. 80-40. On the 13th of March 2013, the bill passed a second reading on a 77-44 vote, and on the 17th of April 2013, the bill passed its third and final reading on a 77-44 vote. Significantly, 27 out of 59 members of the National Party, that's to say almost 50% of the National Party, voted in favour of the measure, as did 30 out of 34 members of the Labour Party and all of the minor parties except the New Zealand First Party and the independent Brendan Horan. The bill received the royal assent 2 days later, and on the 19th of August 2013 the amending Act came into force when it received the royal assent. All of you will have seen, as I did in Australia, the very moving scene in the Parliament of New Zealand on the passage of Louisa Wall's legislation. It said a lot about New Zealand and its community, and it was, for many people around the world, far from New Zealand, a signal of hope and of dignity and of equality. In the United States of America, they had to go through much the same process, but they had certain additional weapons and certain additional opponents. They had to start by overcoming the discriminatory legislation which existed in many states against LGBT people, based in part upon religious attitudes and teachings, but also in part upon laws which were already in place. In 1996, in a case from Colorado, the Supreme Court overturned a constitutional ban on funding and anti-discrimination laws in that state of the United States. And more significantly, in 2003, in the case of Lawrence against Texas, the Supreme Court of the United States struck down the British inherited anti-sodomy law that was in force in the state of Texas, and said that that was unconstitutional. In the same year, a very important decision was reached by the Supreme Judicial Court of Massachusetts, presided over by Chief Justice Marshall. That decision was, on one view, very ill-timed because it intruded into the re-election campaign for President George W. Bush, seeking a second term as president, and it caused a great deal of consternation. Applying the equality provisions in the state constitution of the state of Massachusetts in the United States of America, Justice Marshall and her colleagues in the Supreme Judicial Court held that the unavailability of marriage in the state of Massachusetts would be contrary to the equality promise of the Bill of Rights in the state constitution. That led to an enormous uproar in certain circles, political circles in the United States of America, and it led to the enactment of further DOMA statutes, Defence of Marriage Act statutes, both in the state legislatures and in the federal legislature of the United States, forbidding any step that would amount to a recognition of same-sex marriage. That thereby provided a hurdle or an obstacle to same-sex marriage in many parts of the United States. In 2013, in a case called Windsor, the Supreme Court of the United States against Windsor, the Supreme Court of the United States, in a 5-4 decision, ruled that the federal government was required to recognise as valid same-sex marriages which had been conducted under state law. At that point, only 10 states of the United States and the District of Columbia provided for marriage licenses to be available to same-sex couples, but it was a sufficient number of people who were clamouring on the door of the federal courts, asserting that as they had got a valid law under the state of X, they were entitled under the provisions of the United States Constitution requiring recognition of the legal acts of the state concerned, that their marriage should be recognised in other states of the Union. That case succeeded in the Supreme Court of the United States by a 5-4 decision. There had been several cases in the intermediate appellate courts in the United States which had divided both ways, and it was to resolve the difference in their decisions that led to the decision in Windsor. And then on the 26th of June 2015, this year, in the case of Obergefell against Hodges, the Supreme Court of the United States once again had to make a ruling on prohibitions on same-sex marriages in the states and whether they were unconstitutional measured against the federal constitution. The majority in Obergefell held that the due process and equal protection clauses within the 14th Amendment to the Constitution required states to license same-sex marriages and to recognise out-of-state same-sex marriages. In its reasoning, the majority in Obergefell held that the due process clause in the American Constitution included a fundamental right to marriage. That had been said in earlier decisions, including a decision in a case from Virginia which had prohibited marriage between citizens of the United States who were of different races, Loving against Virginia. That decision had been struck down by the Supreme Court of the United States. So to a lawyer, it wasn't an entirely surprising decision to apply the Loving principle to a law which forbade in the state concerned the facility of marriage. Marriage, said the Supreme Court, was a fundamental right under the Constitution. Justice Kennedy wrote the opinion of the majority of the court, and he insisted on the role of marriage in personal life, its importance in safeguarding families, individuals and children, that it was a keystone in the nation's social order, and that it gave effect to individual autonomy, which was a postulate of the United States Constitution. The minority in the United States Supreme Court said that the Supreme Court should not intervene, that there had been a vigorous debate throughout the United States, leading to many state legislatures changing their law, that the essence of the approach of the United States Constitution was that the people should have a freedom to govern themselves, that marriage equality was a matter that rested on the decision of the state legislatures, and that's where it should be left. There was an interesting toning down of some of the antipathetic rhetoric in Obergefell when compared to earlier decisions. Even Justice Scalia was more temperate in his reasoning, and the Chief Justice Roberts, whilst expressing congratulations to the gay community of the United States for the victory which they had won in the decision, and hoping that their celebration would be a happy one, insisted that in his view the Constitution left the matter to the legislatures of the states, and it should not be decided by a court made up of people who were not necessarily representative of the whole of the American community. The third city is Canberra, and it has a very tortuous history of involvement in this matter, partly because it lacks the legal human rights or Bill of Rights provisions that ensured the success of the cause in the United States of America, and partly because the political dynamics have so far worked against the success of marriage equality in Australia. The founders of the Australian Federation, looking to the United States in this as in so many other matters, came to the conclusion that marriage should not be left to states. It should be given to the federal parliament, and it is therefore within the powers conferred by the Australian Constitution to enact laws for marriage and divorce, and in relation thereto to the custody of children. And that is the provision in the Australian Constitution which was exercised as late as 1961, before which earlier colonial and state laws applied. But in 1961 a Federal Marriage Act was enacted. It, like New Zealand's law, did not contain a prohibition on same-sex marriage, but it was argued that it postulated opposite-sex marriage because that was what marriage meant, both in 1961 and in common discourse in Australia, and that is what should be retained. In 1984, a curious thing happened in Australia, not so curious, but curious for this tale, that laws began to be enacted in many of the states of Australia for de facto relationships, to provide protection for people in de facto relationships, both homosexual and heterosexual, who were not formally married. And that set of provisions was in a way a protection for partners in same-sex relationships, but of course it didn't give relationship recognition in the law. In 2004, during the Howard government, legislation was enacted which mimicked the legislation which had been adopted in the United States called DOMA, the Defence of Marriage Act, in a very short envelope of time that Mr. Howard possessed when the coalition was in the majority both in the House of Representatives and in the Senate. A bill was passed which forbade solemnisation of same-sex marriages in Australia, forbade courts in Australia from recognising same-sex marriages which had been effected overseas, and defining marriage as the relationship between a man and a woman to the exclusion of all others for life, and requiring that that definition be read at every marriage which was formalised in Australia, whether in a church or in a marriage, celebrant marriage. In Australia now, about 70% of marriages are solemnised in parks, gardens, under willow trees and other such romantic places, and not in churches. Only about 30% of marriages in Australia are formalised in churches. I don't know what the position is in New Zealand, but I imagine it would be a similar statistic. In 2004, hot on the tails of that step in the Australian Parliament, the Australian Capital Territory legislature, exercising its powers under the Self-Government Act of that territory, enacted what it called a civil union law. This didn't purport to give marriage as a status, but civil union, providing for civil unions. However, the Howard government opposed the legislation, said it was too close to marriage, calling it a union was describing it as effectively a marriage, and they therefore disallowed the law enacted by the ACT Parliament. I think I'm right in saying it's the only law which has been passed by the legislators of the ACT since self-government in 1988 to be disallowed by the Federal Parliament. In 2007, the Human Rights and Equal Opportunity Commission of Australia, in the face of this development, opened its own inquiry into discrimination in Australian laws on the basis of sexual orientation, gender identity. And it came up with an extremely strong report identifying 85 laws, federal laws, which it said needed to be reformed in order to remove discrimination against same-sex couples and same-sex individuals. That was placed on the table of the federal parliament, but the Howard government, still then in office, said that these proposals were not a priority. In 2007, later in the year, the Rudd government was elected, and the Rudd government very quickly committed itself to amend not 67 but 200 federal laws in a whole range of matters to remove discrimination, but not the Marriage Act. The Marriage Act, pursuant to an assurance given in the election, was not touched. In 2008, the ACT legislature enacted what it thought might be a civil relationship that would be accepted by the Rudd government, called a Civil Partnership Act. They took out every reference to union and called the relationship a partnership, and they thought that that would pass muster with the Rudd government. But observing the commitment which had been given to opponents of gay marriage before the election, Mr. Rudd declined to move. 2010, the Australian Labor Party, which had by then switched to Julia Gillard, adopted to change their national conference mandate to commit to same-sex marriage, and various steps were taken in the federal parliament friendly to LGBT people by the Rudd and Gillard governments. But nothing had been done to amend the Marriage Act when the second Rudd government failed and was rejected by the people in the election of 2012. However, the ACT legislature would not take no for an answer, and it tried for a third time to enact the Marriage Equality Same-Sex Act of 2013. And its reasoning was this, that if the federal legislature has rejected, as the 2004 statute of Mr. Howard had done, the possibility of a marriage under the marriage power of the federal parliament, that still left the glass half empty to be filled by the state or territory legislature. And because it would not be inconsistent with a territory legislature to enact a form of relationship which they called marriage, but only a territory marriage. And they said that by that means they would sail between the prohibition of the Federal Marriage Act and the decision of the ACT to provide a territory marriage, which was not a federal marriage and not purporting to be so. Meanwhile, in May of 2015, the Irish referendum was held, but before that, the challenge was made by the Abbott government to the ACT legislation, and the challenge was successful in the High Court of Australia in the end of 2013, when the High Court said if you call it a Marriage Equality Act, and if you are using the word marriage, and if you are trying to enact a form of marriage, then you are intruding into the space of the federal power, which has used its power to forbid marriage and forbid recognition of marriage, and that is something that a territory or a state cannot do. And so in Australia, we reached the position in the last few months where attempts have been made in the Australian Parliament to get a conscience vote, to have a vote, and to have a decision on the matter. To get a conscience vote, it was necessary for the coalition parties to override the decision of its then leader, Tony Abbott, who had said there would not be a conscience vote in this Parliament. The attempt to do so was put to a party meeting on the 12th of August 2015, and that meeting voted by 60 to 33 against reopening the decision of the coalition not to allow a conscience vote. Notwithstanding that, a number of committed coalition politicians said they would continue to move for a conscience vote, and they relied upon a tradition in the coalition parties that members can vote on conscience matters as they please. And that essentially is where it stands, except for a development that occurred last week in the removal from office of Prime Minister Abbott and his replacement by Mr Turnbull. Mr Abbott was to the end opposed to marriage equality and same-sex marriage. Mr Turnbull has for a long time been a supporter of marriage equality and still is. However, in order to gain the support within the coalition parties, he committed himself to continue the policies which had been adopted by Mr Abbott, namely no amendment to the conscience vote, and before any vote in the federal parliament, the conduct of a plebiscite amongst the Australian people to see whether the Australian people support or do not support marriage equality. The history of plebiscites and referenda in Australia, which is an exceptional procedure, very, very rarely undertaken except for constitutional matters, is almost uniformly negative to the proposition which is being advanced. And of course that was the reason why this was proposed. There is no need for a referendum because the High Court of Australia has made it clear in the ACT marriage case that the federal parliament and the federal parliament alone has the full constitutional power to enact marriage equality, and they went to the point of specifically excluding the argument that marriage meant marriage in 1901 when the Australian Constitution was adopted. So that's where we stand, and I want now to mention very quickly the 10 lessons from what was unimaginable 15 years ago to a point where marriage equality now, at least in Western societies, appears to be inevitable. First, it teaches the importance of scientific research. It teaches the importance of social science research, because nothing much happened in respect of human sexuality and the law until the research of such scientists as Alfred Kinsey in the middle of the 20th century. It was the gathering of a great deal of social science research that revealed that, contrary to expectations, LGBT people were not a tiny minority, but were a substantial, significant minority who should be respected. Secondly, it shows the way in which parallel issues of discrimination happen together and often in tandem. Discrimination on race, discrimination on gender, discrimination against Indigenous people, and discrimination on the basis of sexuality. All of these are part of a paradigm of removing old discriminations. Thirdly, it shows how important repeal of the criminal laws was. The French, you see, had abolished their anti-gay law in 1793, in the early days of the French Revolution. But it has taken until 1967 for the UK to do it, 1986 for New Zealand to do it, 1996 for Tasmania, the last state of Australia, to do it, and 2003 for Lawrence and Texas to do it in the United States. Fourthly, it shows the importance of international movements in the law. The international movement in the Netherlands for the enactment of the so-called law on the opening up of marriage didn't come until 2000, with effect from 2001. So it's a very recent development in the law. 2000 until today is 15 years, and it's truly a most remarkable change that has happened, just looking at it as objectively as one can, to achieve all these changes in such a short space of time, and to achieve the 62% of the Irish referendum in 2015 was a truly remarkable feat of citizen decision-making. Number 5, is the decline of the political influence of the churches. And there are many reasons for this. They include what even Pope Francis has been inclined to say, that there's been far too much concentration on sex and on bedrooms and too little involvement with things that really concern citizens, including religious citizens. Number 6 is the maturity, the growing maturity of the secular principle in constitutional arrangements. Secularism, I think, is one of the most important gifts of the British. They gave the anti-gay law, but they also gave many great constitutional gifts, and one of them is the principle of the separation of the church from the state and the separation of the power and influence of the church far beyond the temple. That is something which has been demonstrated by the votes in legislatures and the decisions in courts. The next, sixthly, in most jurisdictions, it has been an interactive procedure between legislatures and the judiciary. It's unlikely that the Supreme Court of the United States would have taken the case, except for the fact that I think it was 33 states of the United States, and then 36 by the time of the decision, had made legislative changes in the United States. And that encouraged the Supreme Court of the United States to take the decision. Maybe in a perverse way or a different way in New Zealand, the decision was taken in response to Quilter and in response to the feeling that Justice Thomas had got the analysis correct, as was my later consideration of the matter. Eighthly, there are different reasons of where we've got in the different countries. New Zealand, a country with a small population, with a legislature of a single chamber, with a very strong sense of community, which doesn't exist in large continental federal countries. The United States, the galloping number of states which had enacted marriage equality. Justice Scalia and Chief Justice Thomas said that should just be taken as a reason to leave it to the states. They were doing their job, but the majority was of the view, obviously, that it shouldn't be left. It was a matter of fundamental principle and so should be changed. In Australia, we have no Bill of Rights. We had adverse political players of considerable power, and the religious organisations continued to play a very important part in opposition. Ninthly, there is the generational shift as a reason why in Western countries things have changed. Many young people to whom I speak about the subject simply cannot understand the opposition. People want to go down the path of a disastrous marriage relationship. Why should they not be able to do that like straight people? On the other hand, in non-Western countries, there is a geopolitical cultural resistance to change, which is often founded on notions of identity and of religious instruction. And the 10th lesson is that timing is everything. Timing in this matter has been extremely important. There are people who say it is not for the people, the population, the majority, to purport to override fundamental rights, that belongs not to the majority to dispense, but to the people who are most directly concerned. But certainly, as my great teacher in law school, in jurisprudence, who was once the Dean of Law at the University of Auckland, Julius Stone, whose portrait is found just outside the Dean's office so that he can be reminded every day of what a great lawyer Julius Stone, his predecessor, was, and be inspired by his presence. Stone taught all lawyers have leeways for choice. They have leeways for choice in the words of statutes, in the words of constitutions, and in policy decisions which are made under important legislation. Those leeways for choice have to be recognised and seized. Here is the Washington Post on the day after the Supreme Court of the United States announced its decision. Gay's right to wed affirmed. jubilation for many, but day takes bittersweet turn for some. And the White House in the background, you'll see, is coloured in the rainbow colours. President Obama having been a belated but ultimately a strong supporter for marriage equality in that country. And so I leave this saga as a story that is as yet incomplete. In my own country, it is incomplete because it hasn't yet been achieved in Australia. But more importantly, it is incomplete because in 42 of 54 countries of the Commonwealth, we're not talking about marriage, we're talking about cruel violence, hatred and violence, physical violence against people who are LGBTIQ. And it behoves all of us who live in peaceful countries which live under the rule of law to seek to advance equality for all, not just for gays, but for everybody, so that there is no discrimination against people on the grounds of race, on the grounds of gender, on the grounds of sexuality, or on any other irrational ground. And in due course, that will be achieved. And much has been achieved in the last 15 years. Remarkably much has been achieved. And in New Zealand, you have been in the lead on many of these issues. So thank you for allowing me to give this lecture. And in due course, on the demand of the Dean, who is voracious in his demands for my activities, and on the demand of the Auckland University Law Review, I will reduce it to writing, and it will be available for all who are interested. Good afternoon. Thank you.